So form over substance, that's my only reaction when I'm asked about the Munchee app, which arguably was probably not that great of an app to begin with, but they had an idea for an ICO, and conceivably, when you look at it and you delve into what they represented in terms of function, you had a utility token. The S.E.C. didn't necessarily, when they came in and they filed an administrative cease and desist action this week, they didn't deny that, right? And of course, utility token is really not a term of art yet. Us in the industry, whether you're from a legal or technical perspective or investing perspective, it's just sort of what you conceive it to be. It's not a term of art, such as a definition of a security. But in the administrative order that was issued, the S.E.C. makes reference to it being a utility token, and arguably it was. The token, as I read it and understand it within the concept of the app, was only usable within the app, right? And, that is truly what a utility coin or utility token really is, and really what a coin should be, and then what a utility token is and represents, which are, in a sense, the same thing, and that's a participation in an economy. And it's not supposed to hold value outside of that economy. And that's what the Munchee token arguably was supposed to be. But again, we're looking at form over substance. I think the argument could have been made better from the Munchee side, from the app people side, in terms of what they were actually selling, right? What they didn't do, and what I think ultimately brought the S.E.C. to their door, was the fact that they made wild claims, almost penny stock, pump and dump-ish claims on the purported value of these coins and how that value was going to increase. I mean, without even looking for it and without even knowing about it, I knew about this app before the S.E.C. even got involved because I would see it. And their claims were, their advertising, their marketing was entirely focused on the return that one would conceivably obtain if they bought the token. And that return was predicated upon other things happening, such as there being secondary exchange listings, and then even once on those secondary exchange listings, the price going up. So even though conceptually they should have done this correctly, and they could have structured this in the licensure type manner and said that this is a utility token, here's why, their marketing and the positioning, in my opinion, wasn't correct. They went outside of their way to tout the potential investment-like gains that could be attributed to the token if one were to have participated in that ICO. And that was mainly just appreciation. So, contrast that to like the DAO token, where the securities type indicia that was related to that token was like dividends or voting rights. Well, here, the S.E.C. effectively called the token an investment contract. An investment contract is much like almost a CD in a sense, where you're promised, you put something in, you're promised something in return, a lot like a loan, but without security in a sense. So the touting and the marketing, while arguably correct, whether you wanted to believe it or not, sort of trumped the actual utility of that token. And so it's this cautionary tale, because if you truly have a utility token, you still can't treat it like a security, right? The devil's in the details. And if you want to follow sort of the licensure model that, falls outside the Howey test, and I'll get that to a moment, you have to keep with that message. It's all about the optics. It's about the optics of what your investors are being told, what they sign, what they agree to, what your marketing says, what your white paper says, what your risk disclosure says. And while their documents were fine in a sense, simply calling it a utility token and it inherently appearing like one doesn't make it so. And so when you look at it from an optics standpoint and from a third-party standpoint, from the regulator standpoint, it was an investment contract because all they did was tout not the utility of the token and not the utility of the platform that the token was usable on, but rather the fact that the price was going to go up because it was going to trade on second and third party exchanges. And while that may be true to an extent, right, subject to, typical risks, it's not something that I would include or make a part of my marketing. And that's what ultimately sank this, because the whole perception's wrong. The perception and reality are always going to differ, especially when you're talking about something like this, especially when you're talking about, regulation and marketing. But they took something that very easily could have fallen outside the ambit of the Howey test, but their marketing and their disclosure was so poor that it made it appear to be a security. It made it appear to be a speculative venture when utility token, in theory, shouldn't be a speculative venture. It should be literally just access. It should be access. It should be a right. It should be a license to use something. And you can tout the viability of the product. You can tout the viability of the platform. You can tout the utility of it. You can tout, if it's a game, you can tout how much fun it is. It doesn't matter. But they simply went and touted the fact that this was going to compound in value on secondary exchanges. So I don't care how you positioned it. I don't care what you said you were giving to people in the documentation. What you disclosed to the public was that this is something you should buy because the price is going to go up. And the whole concept of economics and bubbles aside, nothing could be more indicative of a reasonable expectation of profit, right, Howey test, than that. So I don't mean offense, but the Munchee app people got it completely wrong and didn't need to find themselves in the predicament they did. They just got greedy, quite frankly. If the app was that good, tout the utility of the app and the buyers will come. And if the secondary market creates itself, well, it creates itself. You can take your own steps to create that market. But that's post ICO, so you don't have to worry about it. And so, whatever you call it, I guess the cautionary tale in summary is call it a utility token. That's not defined anywhere. The S.E.C doesn't even have a definition for that. Say that you did the Howey test like they said they did in their thing. Who did it and why does that count? It doesn't count. You could get 20 attorneys to tell you different things. It's all about optics and it's all about perception, and their perception and optics were completely backwards. It made no sense, and they sunk what really otherwise would have been a very clean utility token type ICO by not focusing on what's the utility, which is the platform and the technology, and focusing on the secondary market and this token and why it'll compound in value through nothing that the company itself would seemingly do other than pump it. So I don't think as a whole the admin action really weighs too heavy on regulation of ICOs. I think it's sort of it should tell you something, but if you really know anything about securities law, or your attorney does, it shouldn't surprise you that much, because when you really look and drill down into what they did, it makes a lot of sense. So, I guess if you could take anything away from it, if you have a utility token, you have to be consistent. You have to be consistent in disclosure. You have to be consistent in what your ICO purchasers agree to. And you have to have something there. You have to have that risk-based disclosure. You have to have some sort of purchase agreement. And you have to have these things clearly defined. And your marketing has to jive or coincide with what you're purporting it to be. You can't simply say it is something and assume that that's all you need to do. So that's my take on it. I'm sure there'll be plenty more of these. This is notable in a sense because no one lost any money, and there had been very limited activity, but I think the amount of marketing that they had done and the aggressive nature of the marketing as it related to the promised returns or expected returns was enough to catch a regulator's eye. So it's my take on Munchee. Check me out, tracyfirm.com. Cheers.